Good morning, distinguished ladies and gentlemen, members of the Fourth Estate of the Realm. Thank you very much for attending this event, the presentation of a communique on the National Summit on Justice that was held at the National Judicial Institute, Abuja, from Wednesday 24th to Thursday 25th April 2024. This communique is issued following a very productive 2 days. The theme of the summit was repositioning the justice sector in Nigeria, constitutional, statutory, and operational reforms for access and efficiency. The focus of the summit was on promoting cooperation and collaboration between all justice sector stakeholders in Nigeria. And the key areas of discussion included the validation and adoption of the revised National Policy on Justice 2024 to 2028, which outlines a roadmap for significant reforms in Nigeria's justice sector. And the second was consideration and consensus building on specific justice sector reform proposals. These reform initiatives aim to reposition the Nigerian justice system through a combination of constitutional, statutory, and operational changes. Ultimately, the goal is to ensure improved access to justice and greater efficiency in justice administration. The meeting began with an opening ceremony which was attended by His Excellency, the President, President Bola Tinubu, who was ably represented by His Excellency, the Vice-President Kashim Shettima, who declared the summit open. The summit also had in attendance dignitaries such as the Senate President, Senator Godswill Akpabio, CON, the Chief Justice of Nigeria, Honorable Justice Ariwoola, CON, the Honorable Attorney General of the Federation and Minister of Justice, who was also the Chief Host, Prince Lateef Fagbemi, SAN, the Minister of Interior, Honorable Olubunmi Tunji-Ojo, the Chief of Defense Staff, General Christopher Musa, OFR, the President of the Nigerian Bar Association, Mr. YC Mekiao, OON, SAN, and the former Chief Justice of Kenya, Dr. Willie Munyoki Mutunga, EGH, who was the keynote speaker amongst the host of other dignitaries. The opening ceremony had welcome addresses from each of these dignitaries. The Honorable Attorney General of the Federation gave a welcome address in which he emphasized the purpose of the summit as being to serve as a platform for stakeholders to discuss and address critical issues affecting justice administration in Nigeria. These issues he listed as including access to justice, improving efficiency in service delivery, and strengthening the independence of the judiciary. The revised National Policy on Justice, he said, proposes interventions in areas such as human rights protection, fair trial mechanisms, alternative dispute resolution, and technological advancements for a more efficient system. The summit acknowledged the importance of collaboration between various stakeholders, including the executive, the judiciary, the Nigerian Bar Association, and various development partners to achieve these goals. Welcome addresses were also delivered by the President of the Nigerian Bar Association, the Chief Justice of Nigeria, the Chief of Defense Staff gave goodwill remarks, and we had a very incisive keynote address from Dr. Willie Mutunga, the former Chief Justice of Kenya, in which he emphasized the overall importance of safeguarding the judiciary from political influence for a fair and impartial justice system. Dr. Mutunga, while presenting Kenya's constitutional reform journey as a potential model for Nigeria, highlighted key areas for improvement, including revamping legal education to prioritize public interest litigation and ensuring broader access to justice for all Nigerians. He also suggested a comprehensive review of Nigeria's constitution to strengthen its democratic foundations. Beyond national borders, he called for Pan-African collaboration in the legal sphere by proposing the establishment of a central institute dedicated to legal scholarship and collaboration across the continent to foster a unified legal framework for African courts, ultimately strengthen the legal system of all African states. The Senate President, in his own remarks, noted that the National Assembly is committed to integrating the proposed reforms into ongoing constitutional amendments and prioritizing measures to reduce court backlogs and delays. He made specific proposals such as requiring all appeals in civil cases to occur after the conclusion of the case, abolishing, to the extent possible, interlocutory appeals that delay proceedings, and replacing the requirement for the Attorney General's consent for the execution of judgments with a notification system that will oblige judgment creditors to notify the Attorney General with a set response deadline. He also highlighted the need to harness technology for case management and emphasized the importance of collaboration between the National Assembly, the Ministry of Justice, the Judiciary, the Nigerian Bar Association, and all other stakeholders. He noted that they all play a crucial role, or they would all play a crucial role in implementing the reforms that were being proposed and in ensuring a just and efficient legal system for all Nigerians. His Excellency the President, as I said, ably represented by His Excellency the Vice President, extended gratitude for the collaborative efforts on justice sector reform, highlighting the significant effort of his administration in providing increased funding for the judiciary. He emphasized the crucial role of a functional justice system in supporting economic growth and safeguarding basic human rights. He underscored the urgency for leaders of justice sector institutions to prioritize comprehensive reforms. These reforms, he said, should aim at enhancing access to justice, ensuring timeliness, maintaining quality, and fostering accountability and transparency within the system. Professor Tabiu SAN, who led the team that oversaw the preparation of the National Policy on Justice, presented the policy to the summit, and he noted that the policy was developed through a comprehensive consultation process initiated by the Honorable Attorney General of the Federation and Minister of Justice. This consultation process culminated in a technical session for all Solicitors General and Permanent Secretaries in the Federation, chaired by the Solicitor General of the Federation, Mrs. B.E. Jediagba, OON-MNI, where they reviewed and validated the draft policy on 23rd April 2024 in Abuja. This collaborative effort was to ensure that the policy reflects the needs and priorities of the justice sector stakeholders as a whole. Goodwill messages were delivered by development partners, Dr. Oliver Stolpe of the UNODC. Also we had goodwill messages from UNICEF and International IDEA, Mr. Robert Sharamo of International IDEA, Samuela Isopi of the European Union delegation to Nigeria, amongst others. The validation of the national policy on justice was conducted by Mr. Felix Otaokoje, who is sitting right here with me, and it was moved. There was a motion moved by Mr. Lateef Fagbemi, SAN, for the adoption of the policy, which was seconded by Mrs. Boma Alabi, SAN, and the national policy on justice was adopted as proposed. This national policy on justice 2024 to 2028 will now serve as a roadmap, paving the way for a more efficient, equitable, and responsive justice system for all Nigerians. After the opening ceremony, we had 3 technical sessions, one on the 24th, which was day 1, and 2 on the following 2 days. The technical session on day 1 focused on judicial appointments and selection as an area of concern. And the specific themes that were examined were: 1, assessing the performance of the National Judicial Council in discharging its responsibility for judicial appointments into the superior courts of record. The second was examining the structure and role of the state judicial service commissions in the judicial appointments process. And the third was in examining the philosophical underpinnings of the judicial appointments process, structural and constitutional dimensions, and the proposals for constitutional and legislative reform. Each of these sub-panels, or each of these themes, were examined by panels made up of distinguished legal luminaries and experts who shared their views on these topics. The first panel was moderated by Mrs. Funke Adekoya, SAN, and had Honorable Justice Benedict Kanyip, the President of the National Industrial Court, Dr. Oliver Stolpe of the UNODC, Professor Amezekwu Obadia of the Faculty of Law, University of Lagos, and Dr. Muiz Banire, SAN, as members, Dr. Muiz Banire being a former member of the NJC. The general consensus reached by this panel was that the role of the NJC in discharging its responsibility for judicial appointments into the superior courts of record required significant review. There was a concern expressed about the fact that the Chief Justice of Nigeria, who is the chairman of the NJC, is also the chairman of the Federal Judicial Service Commission, which is the body that initially reviews proposals or lists of candidates for appointment into judicial office. The members pointed out the seeming inconsistency between the Chief Justice of Nigeria playing both those roles, as it would appear that he was then recommending candidates to himself, being chairman of both bodies, and being the person who appoints a significant number of the members of both bodies, other than those who are statutory members. The proposals for reform that had been made by the Nigerian Bar Association were considered and approved in modified form. There's a general consensus, or there was a general consensus, that there was a need to reconstitute or propose the reconstitution of these bodies, both the National Judicial Council and the Federal Judicial Service Commission. The second panel examining the role of state judicial service commissions was moderated by Dr. Uju Agomo and had as panelists Justice Alaba Omolaye Ajilaye, PhD, retired, Professor Oyelowo Oyewo, SAN, former Dean of the Faculty of Law, University of Lagos, and former Attorney General of Oyo State, Mr. Wale Fakonda, SAN, former Attorney General of Ekiti State, and Dr. Musa Aliyu, SAN, former Attorney General of Jigawa State and current Chairman of the Independent Corrupt Practices Related Offences Commission. Thank you very much. The second panel also focused on the role of the State Judicial Service Commissions and also concluded that there was a significant need for reform in the performance of their roles. There were quite a lot of observations made by the three former attorneys general who had participated as members, as statutory members of the State Judicial Service Commissions in one form or the other, about the composition of the State Judicial Service Commissions, about the need to ensure that that composition is more diverse, that it reflects the interests of the users of the justice sector. And perhaps most pointedly was the observation made by Justice Alaba Omolaye Ajilaye about the fact that the current NJC guidelines may have subverted the intent of the constitutional provision empowering the State Judicial Service Commissions to make judicial appointments, because the NJC guidelines, rather than authorizing the State Judicial Service Commissions to prepare a short list of potential candidates for judicial appointments, appear to have vested that responsibility solely in the chairman. And the chairman of the State Judicial Service Commissions are the chief judges of the states. So there was a pointed suggestion that in the short term, even before we get to constitutional amendments regarding the composition of State Judicial Service Commissions, a low-hanging fruit that could be dealt with immediately is an amendment of that aspect of the NJC guidelines to make clear that the development or preparation of shortlists of candidates for judicial appointments is something that is to be done by the commissions as a whole and not just by the chief judges. The third session, which dealt with the philosophical underpinnings of the judicial appointment process, structural and constitutional dimensions, and the proposals for constitutional and legislative reform, was moderated by Professor Dakas, CJ Dakas, SAN, a former Attorney General of Plateau State, and a very active and committed member of our planning committee. The panelists were Dr. Olisa Agbakoba, SAN, a former president of the Nigerian Bar Association, Professor Yusuf Ali, SAN, Mr. Joseph Otte, who is the convener of the Access for Justice, and Dr. Jan Van Zyl Smith, who is the acting director of the Bingham Center for the Rule of Law in London, England, who came down from London to participate in this session. The session considered the general approach that ought to be taken to reforming the judicial appointments process and stressed the fact that the focus should be on, one, improved or increased transparency in the appointments process, a focus on meritocracy, and a focus on meaningful performance evaluations of those who seek judicial office. The recommendations were made that we should consider the model that is currently being used in Kenya, and also there was a consensus that there is a need to codify the judicial appointments process such that the discretion that is currently witnessed in the appointments process is reduced to the barest minimum. The second day of the summit focused on, the first session of the second day focused on funding, budgeting, and administration for the judiciary. The first session was titled Examining the Efficiency of the Current Constitutional Framework for the Funding, Administration, and Budgeting for the Judiciary in the Allocation of Resources and Accountability on the part of the judiciary. This session was to have been moderated by Mr. Etigwe Uwa, SAN, who was unavoidably absent, and I had to stand in for him. The panelists were Honorable Justice Issa Ayosalami, retired President of the Court of Appeal, Honorable Justice Oludotun Adefokwe Okoje, a retired Justice of the Court of Appeal, and Mr. Robert Emukweros, SAN, who was the lead consultant to the Senate in the last Constitution Amendment exercise. We examined the current constitutional framework for the funding, administration, and budgeting for the judiciary, and as with the previous day's sessions, concluded that there was a need for significant reform. It became evident from interaction with the audience present, which was made up of a significant number of chief judges of the various states and of the various courts and grand cadis, as well as the attorneys general of quite a lot of the states and the Honorable Attorney General of the Federation, that the current process for funding the courts was totally deficient. It became evident in the course of the session that the provisions of the Constitution as amended by the Fifth Amendment authorizing or directing that funding for the state courts should be a joint effort carried out by the executive and the judiciary was not being implemented in any shape or form in the majority of the states. And clear recommendations were made that this was something that needed to be pursued and dealt with decisively. It was evident in the course of the session that perhaps the funding for the judiciary at the federal level is at a much better, is in a much better position than what obtains in the states of the Federation. The second session dealt with examining various models for professionalizing the administration of the courts whilst ensuring the independence of the judiciary and proposals for constitutional and legislative reform. This session, again, was moderated by my humble self. The panelists were Honorable Justice Kashim Zana, Chief Judge of Borno State, Dr. John Sorabji, who is a subject matter expert from the University College London, who joined us virtually, and Professor Bolaji Owasonye, SAN, the immediate past chairman of the Independent Corrupt Practices and Other Offences Commission. Again, the consensus was on the need for significant reform. It was a very lively session that was held on this one. We arrived at a consensus that, yes, there's a need to professionalize the administration of the courts. There's a need to appoint persons with clear administrative experience to be selected through a transparent process to administer the courts and to separate the administration of the courts from the administration of justice. I think the area of debate was not so much as to the common sense behind this, but as to who should exercise the power to appoint these administrators so as to ensure that the independence of the judiciary was not subverted. And the consensus was that that was something that would be taken back and debated in the course of crafting the appropriate legislation. But there was a clear consensus on the need to improve to professionalize the administration of the courts, acknowledging the fact that judges are, by their training, not versed in administration or management, but are trained to adjudicate over cases. The third session of the day dealt with eradicating delays in the administration of justice, agenda for leveraging the rules of procedure and effective case management in Nigeria, and the focus was on the administration of Criminal Justice Act laws and the administration of civil justice law. The session was moderated by Professor Peter Akpabio, SAN, of the Nigerian Institute of Advanced Legal Studies, and the panelists were Mr. Isaiah Bozimo, SAN, former Attorney General of Delta State, Mr. Babatunde Fagbemi, SAN, and Mr. Fernandez Marcos Obiene, the SA to the President on Justice Sector Reform. The panel considered a variety of proposals and strategies that could be employed to enhance the speed of justice delivery in Nigeria. Most of these proposals were accepted by the panelists present and by the audience as being worthy of adoption. To name a few, considered the importance of limiting the jurisdiction of the Supreme Court and ensuring that matters that would go to the Supreme Court would only be matters of significant national importance, and even at that would only be by the leave of the Supreme Court, and that the automatic right of appeal to the Supreme Court will be severely curtailed and will be limited only to matters relating to the election into the office of the President of the Federation, Vice President, and governors of the states. The last session of the day dealt with discipline at the bar and on the bench, the case for enhanced disciplinary powers, performance management, and court monitoring. This session was moderated by Chief Anthony Idigbe, SAN, and the panelists were Honorable Justice Mohammed Garba, JSC, Honorable Justice Olushola Williams, retired, Ms. Hadiza Usman of Partners West Africa, Nigeria, and Professor Yemi Akinshaye George, SAN. The session dealt at length with the challenges with discipline at the bar and on the bench, and the fact that these problems of indiscipline at the bar and on the bench were significant contributors to the current inefficiency of the justice sector, and also to the lack of confidence that the populace have or seem to have now in the justice sector in Nigeria. Various proposals were put forward to enhance the level of discipline at the bar, not least of which was the need for there to be clarity as to who has the authority to discipline legal practitioners, and also issues as to how to improve the efficiency of the disciplinary process for legal practitioners. Similar concerns were expressed about discipline and monitoring of performance of judicial officers, and it was agreed that significant steps needed to be taken in these areas to enhance the quality of justice delivery in Nigeria and increase the confidence of members of the public in our justice sector. The consensus at the end of the summit was that the issues raised were topical and significant, and there was a commitment by the Honorable Attorney General and by all present that, having listened to the discussions and deliberations at the summit, there was a need to engage as quickly as possible in converting these discussions and resolutions into draft legislation that would be presented to the National Assembly for inclusion in the ongoing constitution review process, and also for non-constitution related legislation to be implemented almost immediately. With this, we come to the end of this communique, and we thank you very much for your participation. First question in relation to the priority areas. I think, as Mr. Ogundele has said, we narrowed down the priority areas, and that's what determined the thematic areas that the technical sessions dealt with. The first priority area is the judicial appointment process. We believe that that is a foundational matter, because if we don't get the judicial appointment process right, it is difficult to build anything significant on top of that. So the judicial appointment process is one, and they're all related thematic areas. The second is funding. If we don't get the funding and administration and budgeting for the courts right, it is difficult to get the courts to function effectively. So that was the second priority area. And the third priority area is eradicating, to the greatest extent possible, delays in the administration of justice. Again, this is a connected point. If you don't get the right quality of judicial officers, if they're not properly funded, if there's not sufficient number of them, if the administration of the courts is not proper, there's no way you can get efficient and quick justice delivery, which the Constitution promises. So those were the three priority areas focused on in the technical sessions. Of course, the national policy on justice covers a much broader range of issues, but we focused on those three priority areas for now. The question regarding the unbundling of the Supreme Court, that was not one of our areas of focus, but I did mention that rather than unbundling, we are looking at reducing the workload of the Supreme Court by limiting the number of cases that come up to the Supreme Court. It has been noted repeatedly that the Nigerian Supreme Court is probably the busiest Supreme Court in the world. Even cases involving a dispute between landlord and tenant, where what is an issue is 500,000 naira, can go all the way to the Supreme Court at the drop of the hat. The Supreme Court is too busy. So our focus is not on unbundling the Supreme Court, but on reducing the workload and making sure that the Supreme Court performs its true role as a policy court and as the highest court in the land. The third question,
implementation timeline.
Yes, was in relation to implementation timelines. That's probably the most important question, because, as you have said, we've had these summits and workshops time and again, and nothing much happens until the next summit. Our hope and desire is that this summit will be different. The participation of all the stakeholders that are required to make the necessary changes gives us significant hope. I already mentioned that the Senate President was there in attendance. He has indicated his support for the reform initiatives. Of course, the specific timelines within which bills will be presented to the Senate and within which the constitutional amendment process itself will come to an end is not within our control. As you know, amending the Constitution doesn't even stop at the National Assembly. And the National Assembly still has to go to the houses of assembly of all the states. So it is difficult to say this is the timeline. All we can assure you is that this current Honorable Attorney General, to the best of my knowledge, has every intention to pursue this reform initiative to a logical conclusion within the shortest possible time.